17.
7.
17.
You have not given any.
I was out of session. I'm sorry, my lord. Since Thursday, I came to the MDS.
Mr. BZ Talukdar. Learned Michael Curie prays for adjournment. To survive the same is not objected to by Mrs. Jahan additional thinking. This is the matter after.
Any day.
This is the matter after a week.
Any.
Is there any eyewitness in your case?
No eyewitness. I have just hurriedly gone through, but no eyewitness. All surmises, my lord. I'll place it before you also.
Yes.
My lord, my case number is 2571 15. 2015. It is
Item
lying
15.
2015. It is lying for 1 year.
Oh, it is pending.
For
Okay,
listing.
okay, listen. When do you want?
2571.
When do you want?
WBC.
WPC will not. be
WPC?
taken. I think he's mistakenly come. WPC, it's a division. right?
Yes.
Maybe he's mistaken. He is.
May I please, your lordships, with the consent of the other side, I like to mention item number 19 of today's daily list. May I pray for some accommodation?
Okay, right. On the prayer for adjournment made on behalf of. Huh?
MD1, my lord. For the
Made by Mr. MD1. Which is not objected to by Mrs. Jahan additional people. This is the matter after
3 weeks, my lord.
3 weeks. 302 matter.
Now, for the second check.
Yes.
My lord, so far as the defense service regulations are concerned, my lord, on the query so put. You will. The relevant extracts are there. My lord takes the third page. Non-commissioned officer.
Third page.
Third page. Non-commissioned officer.
Yes.
This is the defense service regulations of the Indian Air Force. An airman of the rank of flight sergeant, or corporal, and it includes corresponding airman, aircrew. That is non-commissioned officer. Now, may I invite my lord's attention to the next page? Airmen, chapter 6, 285. The first one, LAC to corporal. It is airman. LAC is airman. Airman is non-commissioned officer.
No, wait a minute. You're a LAC.
I am an LAC.
So your LAC is not a corporal.
No, LAC is a non-commissioned officer. Corporal is
Huh?
also a non-commissioned officer.
No, how do you say?
I
LAC
put
is
it this way, Milo. I put it this way. Non-commissioned officer means an airman of the rank of flight sergeant, or corporal,
correct.
and includes
And
includes corresponding airmen.
correct. But then
This
we
is
see-
airman,
Just a minute.
my lord.
A leading aircraft man,
My lord.
is he equivalent to a corporal?
No.
Then?
Leading aircraftsmen and corporal both are non-commissioned officers.
Where do you get that? It's
In
not there.
chapter 6 airmen, it includes an airman. In airman, provided he is otherwise considered fit, the minimum qualifying service to be rendered by an airman in the rank of a substantive or acting paid capacity to be eligible for consideration to the grant of acting paid promotion to the next higher rank will be air follows. All are airmen. LAC is an airman.
They may be airmen, but they're not.
Airman is my
not a
lordship.
but they're not a
My
non-commissioned.
lord, on that touching note, let them get the instructions. I
No,
have.
why you
by
you
the
have to first satisfy the court.
My
It is
lord.
your case. Why should it is your case.
Lordship takes a page.
Why didn't you satisfy this aspect to the
And
to the learned
most-
tribunal?
Most respectfully, if I may say, the argument taken up there was quite the opposite. They went to the corporal rank, which I am now trying to satisfy your lordship is that regardless of being promoted as a corporal, regardless of that, if one is holding the rank of a leading aircraftsman, he is covered under the protection of 84 sub-rule 4.
Where?
If 46 for a moment, I may correlate, let them get the instructions on that, Milord. It's an official document, It's an official thing, the rank in the Air Force.
Yes, Mr. He
Read-
says, yes, Mr. Mehdi, he says one thing. He says, according to this does not indicate. But he says that a leading aircraftsman, which rank he is holding, is equivalent to, is a non-commissioned officer. Whether it is a non-commissioned officer,
That's instruction.
that instruction you take. If it is a non-commissioned officer, he has a case.
Yes.
If it is not a non-commissioned officer, he does not have a case. That's the
I'll
long
take
shot
my
of it.
next thing of argument then.
That-
That
that-
was obviously.
Your next limb of argument is on what? On the question of what? On question
On
of
the
fact?
question of non-consideration of my reply.
That's
Paragraph
all.
11,
That's all. That's all.
and had they considered, they ought to have considered whatever I have stated down there. Nothing, not considered.
That,
No, I'll not take it
that
back.
we'll see.
And that I'm not.
That is a different issue.
The different issue.
That is a question of fact.
No, page 46 for a moment. Page 46 for a moment.
Page 46.
Page 46. There is an additional affidavit by the Air Commodore. It's quite higher rank below. Air Commodore files the additional affidavit. Page 46 is second page of that.
It says page 46, second
No.
paragraph.
No, page 45 is the affidavit
Yes,
of the Air Commodore.
yes,
And the page 46, the first paragraph I read,
yes,
is their version.
yes.
That the Honorable Tribunal, while hearing the matter on 35-2022, observed that whether the applicant was a corporal on the date of commission of the offence, 1918, or he was a non-commissioned officer, bracket LAC. So they don't dispute the fact. The question is whether I was a corporal or a non-commissioned officer in the rank of LAC.
No, but then they have clarified that issue.
They
They have said-
clarified
They have
I was
said
a
that-
LAC.
No, they have said that you were promoted.
No. We are not on the promotion part, Minor.
Okay.
The query by
That
the
promotion is from which post to which post?
promotion is LAC to corporal. They denied.
LAC to corporal.
Yes, they denied on the fact that since physical promotion was not given, this promotion does not take effect.
LAC to corporal.
Yes,
Let us see that.
49, Lordship may see, 49. Page 49, paragraph 8. Page 49, paragraph 8, their affidavit. The deponent begs to submit that the applicant was never promoted to the rank of corporal. As such, he was not holding the rank of corporal on the date of commission of the offence on 1918. The applicant was holding the rank of leading
Okay,
aircraftman.
no, anyway, we'll see.
Say for
You take instruction on this. We'll listen again for motion.
on context of page 46 and 49 also, my lord. This is their stand. The reported tribunal had put a query that whether I was an NCO or not. It is not the tribunal disputing with the fact, but the entire projection of the case was wrong with
What
some,
is, according to you, you are a leading aircraft.
my lordship.
And according to them, you are what?
No, I am LSE, leading aircraftman. The argument advanced was that since I was promoted to the post of corporal, so I will get the benefit. Most respectfully, I say, regardless of the promotion, I still get the benefit and protection because LAC, leading aircraftman, is a non-commissioned officer, and this they do not dispute. It is Air Force rank. They will never dispute that.
As per page 46,
46.
Mr. Mehdi,
Yes, madam.
he is a LAC.
Yes, madam.
And LAC is basically a non-commissioned officer,
Non-commissioned officer.
as per page 46.
Yes.
Then whether he can be, whether the action taken upon him could have been done in terms of
Rule 15 to G2.
show me.
It should correlate with 84 of the Act, 84(4). I'll just pass on 84(4).
Show me the rules and the act.
I'm sorry, I'm having only one Air Force Act.
Air Force Act.
How many again?
Air Force Act, section 84.
84. First 82. Because I got 7 days in detention, 7 days. So first 82. 82 confers the jurisdiction to grant a detention up to 28 days. Now 84. 84 subclause 4. May I read, my lord?
Yes,
The punishment specified in clauses A, B, C, E, G, and J of section 82 shall not be awarded to any person who is of the rank of non-commissioned officer or was at the time of committing the offence for which he was punished of such rank.
Okay, so the last punishment was the
Yes.
7 days.
Therefore, fourth red entry does not come in. Therefore, 15(2)(g) would not be attracted.
But you could have been still taken out under 3 red flags.
The procedure cannot be. Under the offender's policy is there, I have to at least get 4, then to be proceeded. So therefore, the discharge on the face of it is barren law.
Where is the rule?
Rules. The rules are appended to the act.
Yeah. He had another book, that's why.
I'm sorry. I ought to have gotten another.
No, it's okay. We have got the rules. 15.
15. If you're holding the same page, running page is 61.
Yes, 15.
15(2)(g)(2). Unsuitable for retention in the Air Force.
15 to
G2.
G.
Unsuitable for retention in service.
Yes, so what do you want to say out there? What is your argument with this rule?
This 15(2)(g)(2), the punishment which was inflicted for 82A, under section 82A, the inflictment of punishment was barren law.
Why?
Because 84(4), I have a protection. The embargo of 84(4) was not
Correct,
considered.
correct. The hardest
If that
15
be so,
Ah.
then the reading punishment which is comes in
that,
cannot be inflicted on me.
so this
If
is-
that
this-
be so,
Ah.
I do not qualify under the habitual offenders policy for the 4, leading the ab initio part, the 4,
So according to this 15(2) could not have been.
should not have been attracted. Very, very good. That's it. This argument was not taken up with all respect and humility. The other argument was taken up, the corporal being so, but that I abandoned that argument. I was not the counsel though.
I don't know whether the council or not. how
Anyways,
does it
it must be
matter?
fair.
So basically, you're saying that council was not competent.
No, he
enough,
was
like
taking it
you.
on a different level, but I take it on a slightly lower
So
level.
his level was slightly on a different level than yours.
But we attacked the same issue.
Okay. Yes, what to do, Mr. Mehdi?
I'll take instruction.
Because this page 46.
Yes, madam.
Your affidavit shows that he was either a corporal or he was a non-commissioned
Yes,
officer.
The 49 says LSC,
Yes.
49
No,
says.
no,
LSC.
and no, and plus I would say non-commissioned
Yes, yes.
officer bracket LAC.
Yeah, obviously,
So that has caused
Yes.
now an issue. Right.
they can still proceed against me, but on a different count. This way of discharge was bad enough.
Okay, right. Heard Mr. S. Banik, learned counsel for the petitioner, who submits that the impugned order dated
6/4/2023.
6/4/2023 passed by the Armed Forces Tribunal, Regional Bench, Guwahati, in OA number 56 of 2019 should be set aside in as much as the
And the
petitioner
discharge of it.
could not have been discharged on the basis of Rule 15 to
G2.
bracket.
15 to G2.
15 bracket 2 bracket G bracket Roman 2 small of the Air Force Rules 1969. Comma, as the petitioner was a non-commissioned officer. Full stop. As such, punishment under section 82 bracket A could not have been inflicted of the Air Force Act 1950 could not have been inflicted upon the petitioner in terms of section 84 bracket 4 of the Air Force Act 1950. Next one, basic argument of the petitioner is that the petitioner being a leading aircraftsman, comma, he is a non-commissioned officer, and as such, he could not have been put in detention for 7 days, as per the last punishment given to him. Next paragraph. With respect to the fact that he was a non-commissioned officer, bracket LAC, is, he relies upon para 1 of the additional affidavit in a position filed on behalf of the respondents number 1 to 6, comma, wherein it is stated as follows, page 46, para 1, I just take it. Next, issue notice, I think.
My lordship, since it's on a point of law, not on the facts we are not on now, it can be disposed of on the next day
So that-
also.
Okay, so that,
Then some we get, some we leave here and there.
then hurry, why?
No, because young man
So.
traveled up to the Pakistan border without-
Let him take,
Got-
the issue notice this, issue notice. Returnable in. 4 weeks. Mr. S.K. Medi, CDC, accept notice on behalf of
All respond.
all the respondents. He shall obtain instructions by the next day as to whether, as to the post held by the petitioner at the time of his discharge from service. Full stop. The CGC shall specifically clarify as to whether the post of leading aircraftsman is also a non-commissioned officer. Take that.
Yes.
This is the matter of the phone.
May I pray for a date, Milo? In fact, we both are praying.
Yes, sir. On 8th of
Give it
September.
Huh?
8th of September.
It's a circle.
Obliged, lordship. Well,
May I please your lordship? My lord, this appeal is filed against the government and
Okay, you also write one thing. The issue of. No, that's. Next, yes.
lordship. The appeal is filed against.
What is your name, madam?
Mrs. Purvi
Mrs.
Barua,
P.B. Bordoloy,
My lord. My lord, I am appearing as legal aid counsel.
Learned Legal Aid Counsel,
My lord,
prays that the judgment dated 24/3/23 passed by the Section Judge Baksa, Mushalpur in Sessions Case number 87/2021, by which the appellant has been convicted under Section 302 IPC, should be set aside. Issue notice, Miss S. Jahan, additional PP, accepts notice on behalf of the state.
my lord, I have also filed a application, my lord.
Yes,
If they admit the appeal,
File-
call for the LCR.
My
This is
lord,
a matter after 4 weeks. Then you write in the 389, Ms. S. Jahan, learned additional PP is granted
3 weeks.
3 weeks time to file, 4 weeks time
Yes.
to file written objection to the application under section 389 CRPC.
My
This is
lord,
the matter after 4 weeks.
my lord, my humble submission is this, my lord, kindly allow me consider my appeal application, my lord. Pending disposal of the criminal appeal, my lord. My
We will,
humble
we will.
submission-
Let her file her written objection. This come for the first time, madam. You want,
Is
we
it
can,
right?
if you want, we can hear it now also.
My lord,
You want to hear it now, it's okay.
my lord.
We hear it, yes. If you want to hear it now. what is the problem?
None,
Yes,
it
what
is
is it?
agreeable.
No, yes, you tell us the ground, why it should be, released on bail? Why the sentence
My
should be
lord,
suspended?
my humble submission is that, my lord, only he is the sole owner of his family, my lord. There is none to look after his parents, old is that parents, my lord. My lord, this is the first time, my lord, no.
Sole bread
earlier-
earner and what else?
Yes, my lord.
And
and look after, there is not a single member of his family to look after their old age parents, my lord. So kindly consider our my bail application, my lord. Pending disposal of the criminal appeal, my lord. My humble submission is this, my lord. Not a
that's all.
single-
I will
On marriage,
dispose it of.
because on marriage, she did not say anything. Let me
That's
find my
fine.
objection.
For the
But
first time, my lord.
No,
in
she
the
wants
past
it,
of
she
the-
wants it disposed now, so we'll dispose it now. So
do it
we'll,
after my objection.
huh? You want to
Excuse
dispose
me,
it
sir.
now?
And then
So my
after
lord,
four
kindly
weeks.
for it. Highly obliged. ma'am.
Yes, heard Mr.
Yes, it does.
S.C. Das, learned counsel for the appellant, who submits that the judgment dated 4/5/2023 passed by the court of the special judge Poxo in special Poxo case number
19.
passed by the special judge bracket Poxo, Kachar, Silchar in special bracket Poxo. It was case number 14 of 2022, by which the appellant has been convicted under. So,
In a near case, notice will go by the.
Motion may admit it and file our objections.
Okay.
right, Mr. Z. Kama, learned counsel for the, learned senior counsel for the appellant.
Yes.
Pays for bail. Issue notice. Mr. R. K. D. Chaudhary, learned. Standing counsel, what is it? Learned deputy SGI, deputy SGI. Submits that he will file affidavit for the respondent within
Motion will grant me 3 weeks. time.
within 3 weeks. This is the matter of it.
Much over.
My lord, in this appeal, on 24/5/23, this honorable court fixed the matter for mediation, but that was failed, my lord.
Now what to do?
My lord, fix the matter for hearing, my lord. Already LCR has come, my lord.
LCR step.
For hearing of the IA, my lord.
Okay. Aye.
I have translated everything in my memo of appeal. My
Ah.
lord may take up the memo of appeal.
Yes,
Yes, my lord, the appellant hearing was by judgment and order dated 18/1/2023, passed by learned additional session judge FTC Lakhimpur North Lakhimpur, was convicted to undergo rigorous imprisonment for life under section 302 of IPC, my lord.
yes,
And my lord, here in this case, there are as many. Here in this case, there are as many as my lord, 9 PWs, my lord, out of which, my lord, PW2 was considered as star witness, and on the basis of that, my lord, the conviction was affirmed, my lord. PW, my lord, I take your lordship to the FIR first, my lord. FIR starts at an enclosure 2, page 35, my lord. With something case.
yes.
My lord, may I read? My lord, the FIR was lodged by the informant herein is the ASI of the outpost, my lord. The FIR states as respectful submission is that with regard to above reference, during investigation, it came to knowledge that on 2/5/2013 at around 7, Srimati Guniti Surin, wife of Sri Abhiram Surin, resident of Harmoti Tea Garden of the Charles Line under police station Laluk, was assaulted by the above referred accused persons as they caught her in her house and took her to the house of accused number 1 on suspicion of her being witched, and because of severe physical assault, she got injured. The injured person, though, was admitted in the
So
Harmony.
this accused number 1 is you.
You, my lord, me. The injured person, though, was admitted in the Harmony Tea Garden Hospital, but as the condition was critical immediately for further treatment, she was referred to North Lakhimpur Civil Hospital. My lord, she died on the way. This is not.
She was branded a witch.
My lord. amended as which, as per the allegations, my
So
lord.
this is a witch hunt.
Witch hunting, cases of witch hunting, but the judgment as was pronounced, my lord, though PW2 was considered as star witness, and more or less it was on the basis of circumstantial evidence, my lord. Here, my lord, with regard to the depositions, my lord, PW2, PW4, the informant is more important, my lord.
The informant is PW.
PW, my lord, 4. And my lord, PW5 and PW6 are also important. PW5 is the medical officer on whose information, my lord, the ASI got information. And PW6 was the person who has done the postmortem, my lord. My lord, may I take your lordship to the depositions directly, my lord? My lord, PW1,
Page.
page enclosure 6, page 51.
Yes.
On oath, on 5/3/2015, I
Page
was,
51 is a postmortem.
my lord, enclosure 6, page 51.
Huh? This is your petition. Page 52 is enclosure 6. You want page 52?
No, my lord, page 52 then.
Page
They
52,
have
yes.
made the corrections,
Page
my lord.
52.
52, I'm on page 52. On oath, my lord, may I read?
Yes.
On 5/3/2015, I was working at Harmony Tea Estate as senior medical and health officer, Harmony Tea Garden. And on that day, I examined one Gunidi Surin female, 65 years, resident of Girja Line, Harmony Tea Estate. And on examination, I found the following. The patient was in semi-conscious state, face badly bruised and bleeding, face, abdomen and neck bears injury mark, and with ulcer. Upper limb, both the hands had injury mark. Arm, forearms bears injury marks and lower limb abrasion present. Blood pressure cannot be detected, pulse 88 per minute and temperature 99°F. Remark, the patient's condition was critical and therefore she was referred to Civil Hospital Saboti, North Lakhimpur, for further investigation and treatment. The injuries were fresh as they were bleeding. My lord, he is the person who has informed the ASI, my lord. My lord, PW2 at page 54, my PW2. May I read, my lord?
Yes.
Yes. And my lord, she is the daughter-in-law of the deceased. Daughter-in-law of the deceased. And she is the only witness in this case, my lord.
Well, how many witnesses do you want?
No, my lord, this will relevant whether she is a star witness or not, my lord, my deputation. My lord, may I read?
Yes.
On oath, I know all the 4 accused persons present on dock, and I also know the absent accused Bijoy belongs to the same village. I know Gunidi Surin, Ibrahim Surin belongs to same village. My lord, here before proceeding, I'd like to say, my lord, only one person was convicted here in this judgment, my lord. Others were acquitted. It is around 3 years that the incident took place. Incident of night. Gunidi was my mother-in-law. On the day of occurrence, while she was sleeping at night, my lord, this is very important. On the day of occurrence, while she was sleeping at night, the accused persons took my mother-in-law from her house to the house of accused Bursa by stating that she is a witch.
Who is Bursa?
Bursa is the accused. My lord, appealant before your lordship. My lord, this is very important. When I followed, my lord, she stated, when I followed my mother-in-law, I saw that accused persons were assaulting her. That is my mother-in-law by sticks, by hands at the house of Bursa. I called the villagers after I saw the incident, but no one came. After assaulting my mother-in-law, the accused persons brought and left my mother-in-law in our house. Thereafter, after accused, she was brought back to her house, she stated. Thereafter, I, along with my husband, took my mother-in-law to the Harmony Tea State Hospital for the treatment. Along with me, my late husband also saw the incident. As the doctor of Harmony stated, the treatment cannot be done there. Therefore, my mother-in-law was taken to Lakhimpur Civil Hospital for further treatment, but my mother-in-law.
Have you submitted your objection?
Yes, my lord, objection was filed. But my mother-in-law was taken to Lakhimpur Civil Hospital for further treatment. But my mother-in-law expired there during treatment. I saw my mother-in-law was nailed, Gozalere Mora, and was beaten in her hand by falling witch. My lord, may kindly see the cross.
What do you mean by nail, Gajal?
My lord, she stated that that big nail, no, my lord, nail, Gozal, nail. So nail was put in her hand, according to her.
Okay.
That is the.
Which is,
in witch hunting cases is generally common scenario that nails are put.
On
In
both the
hand.
hands.
Yes, my lord, this is also something that I have to submit. I have even have made a note. In medical evidence, this was not there. My lord, I come to the cross. My lord will understand whether she is a star witness. I did not state it before police what I have stated today. It is a fact, my lord. It is a fact that I have stated before the police that I taking leave from work in the evening. I along with my husband and child went to visit my uncle's house in the village. And after returning, I saw my mother-in-law lying in the bed, no voice at all. There are injuries in the body. Blood was oozing out from the mouth. On inquiry, my mother-in-law stated that someone has taken her from the house to Gulsha's house, and after assaulting her, has again left her in her own house. Earlier also, the villagers, after catching her and assaulting, thereafter used to leave her at her house. Has stated, it is not a fact that I have deposed falsely today. My
The
lord.
village is scared now,
My lord, this is cross. Just some,
whatever.
my lord, here in the deposition, she has stated, my lord, may I read the deposition once again, my lord? She has stated, my lord, very clearly on the day of occurrence while she was sleeping at night. The accused persons took my mother-in-law from her house to the house of accused Bulsa by stating that she is a witch. When I followed my mother-in-law, I saw that accused persons were assaulting her. That is my mother-in-law by sticks, by hands at the house of Bulsa. I called the villagers after I saw the incident, but no one came. After assaulting my mother-in-law, the accused persons brought and left my mother-in-law in our house. According to her, she followed, she has seen everything. She has also seen that after that, her mother-in-law was assaulted and brought to her own house and was laid, after assault, she was laid in the bed, my lord. And in her prose, she has not stated anything of such. She had stated that, she has stated, I taking leave from work in the evening, I along with my husband and child went to visit my uncle's house in the village, and after returning, I saw my mother-in-law lying in the bed. My lord, completely different.
Then
Lying in the bed, no voice at all. There are injuries in the body. Blood was oozing out from the mouth. And on inquiry, my mother-in-law stated that someone has taken her from the house to Gulsha's house, and after assaulting her, has again left her in her own house. Earlier also, the villagers, after catching her, assaulting, thereafter used to leave her at her house. This is the deposition of PW2. Then I take your lordship to the other depositions, my lord. PW3. Enclosure 8, page 58. My lord, in all the other evidences, my lord, they have simply denied it. They are not aware. Only PW4 is relevant, my lord. May I take to the relevant that
Yes.
PW4 and my lord, enclosure 9, my lord, it may be page 61 in my lord's
yes,
PW4 on 3/5/2013, I was posted at Harmony Outpost as ASI. On that day, I received a telephonic call from the doctor of Harmonic Day State. My lord, this is PW1. Okay,
okay, 2 minutes.
my lord. Says the injuries are antemortem in nature. The person died of head and chest injuries following multiple blunt traumas. My lord, the PW2, who is considered a star witness, he has specifically stated that nails were given in the hand. My lord, those nails are not those nails that we use for wooden. They are Christian people, my lord. More or less, it's like
The fact is,
it's like
it's like
The fact-
crucifixion
yes,
or
my lord.
anyway, the fact remains that she has been,
No, my lord.
so do you mean to say the injuries were not present on
But
her?
injuries are present, but the thing is that Bhusha has done or not is the question, my lord, because all the other persons are acquitted, only Bhusha is convicted. And my lord, PW2 was considered as star witness, and on her deposition, the same was done. PW2, my lord has pointed out, that my lord has stated one query that she might be in fear in her cross. But my lord, she is the one who has narrated the story. She has stated, I was sleeping, they came, mother-in-law, I followed them. I have seen all the witness. After injuring her, she was brought and laid in the bed, and she has seen the nail was put. My lord, that would not be left behind in a postmortem, because those nails are not a single injury with that effect. Those nails might have been the one that we used to see, my lord, big nails. So my lord, injury, with regard to that injury, which has been specifically mentioned, my lord, that is absent in the postmortem and with regard to the evidence of the doctor. And my lord, my submission that PW2 is not a eyewitness. And my lord, while my lord, the other witnesses are the same, my lord. And even my lord, one more witness, PW9. In PW9, who was also one of the investigating officer, he has clearly stated that Renu Suren, means the PW2, has not stated about any person's name at page 77 of my lord's petition. At present, has not stated any person's name, my lord. And my lord, the conviction mainly was granted on the basis of deposition of PW2. Second, circumstantial evidence, no circumstance or
What is the
judgment.
reasoning of the trial court?
Yes, my lord, there I take your lordship to. It starts from my lord, page 20. Page 20, my lord, 5. Page, my lord, page 20, my lord, it says, I can take your lordship to 29 of the judgment, paragraph number 28.
Page?
29.
Yeah.
29. But my lord, there is one more observation. Page 28, my lord may read from paragraph 25. There to,
Yes.
25. May I read, my lord?
Yes.
Paragraph 25. Thus, it is clearly seen that the victim was suspected to be witch as per the allegation made by the prosecution. On that suspicion, all the accused persons were implicated in the Ezahar. PW2 has clearly stated, even in her 161 statement, the victim told her that she was taken to the residence of accused 2 by some people and they assaulted her. However, she improved her statement while appearing before the court for reducing evidence, and she clearly tried to project herself as an eyewitness of the whole incident. Therefore, in view of non-mentioning of the fact that she was an eyewitness while recording her statement under section 161 PW2 cannot be accepted as an eyewitness of the instant case. Paragraph 26. However, evidence of PW2 can definitely be used to the extent that her mother-in-law victim confided to her that she was taken to the residence of accused 2 by some people and they assaulted her. As this is a statement made contemporaneous to the actual statement, therefore, in view of section 6 of the Indian Evidence Act, there is definitely evidentiary value of statement made by PW2. Next, as far as injuries are concerned, it is clear that from the evidence of PW1 as well as PW5 that the victim sustained multiple injuries on her body. Finally, as per the opinion rendered by PW5, the person died of head and chest injuries following multiple blunt traumas. Well, paragraph 28 is important for me. All the incriminating materials were put to the accused and examined them under section 313 of CRPC. However, all the accused have flatly denied the allegations made against them without giving any plausible explanation, my lord. Then with regard to paragraph number 29, she has the learned court has given one citation of one judgment, which is not relevant in my case, my lord, because that circumstance is put to the accused when an accused under section 313, when doesn't give any explanation or proper explanation, the court can draw an inference with regard to making the circumstance complete. This is not relevant. I will take your lordship to 313 also. Then on this three, mainly on this basis, my lord, I take your lordship to even 313 for a second, my lord.
Page?
My lords, it will be, my lord, I guess 83 in my lord's petition. Because one page I am forward, I mean, 83, my lord, in 313. My lord, only the questions that were put to accused, my lord, may kindly see.
Yes.
May I read, my lord? The question number 1, my lord, this person is an illiterate. He also belongs to a poor status that may be also taken into consideration, my lord. So, my lord, I feel that the answers were very direct and very correct also. My lord, first question that was put to him was PW1, Dr. Arun Bora deposed that on the basis of this case, he has doing medical examination of injured Gunidi Soran. Have you got something to say? He stated, I have nothing to say. What he will say in this case? Then, my lord, second, PW2, Srimati Renu Surin has deposed that on the day of occurrence, you took her mother-in-law Gunidi from her house to your house by stating that she is a witch and you assaulted her by sticks and by hands. What is your answer? He stated false statement. Third question, my lord, he is very exactly to be true, my lord. Third question, may we say, EW5, Dr. Diganta Doctor has deposed that he has performed post-mortem examination of the dead body of Gunidi Soran. Have you got anything to say? I have nothing to say. My lord, he has stated, he's a very simple tribal person, my lord. He has stated everything very clearly. how he will know who has conducted postmortem? He stated, I have nothing to say.
Well, that's
And
good for
that-
you. That's
Huh?
good for you.
My lord, that is because my lord, the two questions were put to him. And the last question, my lord may say, I think, my lord, this is, PW, my lord, even the next question also, PW9, Ajit Kumar Bhoi has deposed that he has submitted charge sheet. He also said, I have nothing to say in this case. Then last question, will you give any witness? Do you have anything more to say? He stated, I will not give witness. I am innocent. The case is false. My lord, this person, what he will say more in this? Questions put to him in 313.
So good for you.
The most relevant question that
So,
was,
so you are very lucky.
my lord, one of the most relevant question was with regard to his the day of arrest when he was at the hospital. Nothing was with that regard asked before him, my lord. The questions were 5 questions were put to him, out of which 3 were technical questions with regard to postmodern, charge sheet, and he has stated, I have nothing to say because he has nothing. And 2 questions he has stated rightly, I will not, I am innocent, the case is false, my lord. So, my lord, my submission is that, my lord, and with regard to my lord, my submission is that PW2 was neither an eyewitness, neither she was present at the place of occurrence because her deposition to a specific point was absent in medical evidence. And interestingly, this is out of court after 1 or 2 months of the death of the mother-in-law. The husband also circumstantially at night died. Thereafter, she married and went. So, my lord, the thing is that is out of different thing, but my lord, my submission here is that my lord, conviction is mainly based upon if PW2, I don't think my lord is a star witness. If circumstantial evidence, no circumstance at all, my lord, at this stage, because I cannot find any Katina connection with any of the thing. Many persons were considered accused. He is convicted, my lord. Others were acquitted of the charge. So, my lord, here I said he is the sole breadwinner of the family. And my lord, he is a post strata of the person. He's a permanent resident of that locality. He went of its own. Although during the trial period, he was on bail, my lord. He has appeared regularly. He has never violated any law. So, my lord, may I pray for his bail, my lord, at this.
As far as the contradiction is concerned, we'll have to see the records because before the police, that was immediately after the incident. And there must be a big hue and cry at that point of time, and she was examined and she perhaps was scared and she did not state the real fact because in her statement before the trial court, she said, I have not stated these things to the police. She admitted that I have not stated about my seeing the occurrence to the police. Police, she said, at best a dying declaration. I came and I saw my mother on the bed and she was injured and the mother said. So that was,
Does the mother implicate the appellant?
yes, mother, of course, mother said it was here. She was taken to the house of the appellant,
Only that.
only that. And she was assaulted there,
She was
was badly
assaulted
assaulted. Only that, in the house of the appellant and she was assaulted. And in her statement before the trial court, she said not only about nailing part, she said about sticks being used.
But there is one
assault.
thing. During the 313,
Hmm.
an explanation and an opportunity to explain the evidence
Mm.
against the accused has to be given.
Hmm.
Now, where is the evidence that is against the appellant
Hmm.
in the 313 examination?
No, those were the statements that you had taken the.
No, let us see
This is-
313, page 82.
Yes, 313. The one that she had said that he was in the hospital was not put, that was not as incriminating circumstance.
No, but
Here, here 313, he has doing medical, have you anything to say? Of course, he doesn't have. Deposed that you took her mother-in-law from your house to your house, from her house to your house by stating that she is a witch and you assaulted. So this is an incriminating circumstance.
no, but then says you. Where where the evidence nowhere shows that he had taken.
No, Lordship will see PW2 had stated that he
There's
had
some other
taken.
people, not that doesn't identify this appellant.
PW2, of course, it is an So PW2 had said, Gundi was on that she was sleeping accused persons. Accused persons, of course, is inclusive of the appellant. Accused persons took my mother-in-law to the house of accused Bhusha by stating that she is a witch. So perhaps Bhusha was also there. He also was there while taking the deceased to his house. When I followed my mother-in-law, because there are some contradictions, no doubt. And she had stated in her cross, it is a fact that I have stated before the police so and so. I did not state before police what I have stated today. So the contradiction she has admitted.
Okay, so even he took her. It appears.
It appears because accused persons. No, after I finish. It's accused persons took my mother-in-law to the house of Bhusha. When I followed. And Lordship will see the cross, she stated, she admitted the contradiction. So in view of the admission, it seems she was scared in the first point of time and later she regained her courage and all. And sometimes Lordship has seen in so many cases. Contradiction is related to a particular point, but the entire statement is written. And in what sense? Fact remains, she was taken to the house of applicant if we read both the statements. And she was assaulted there. And she was taken to the hospital. The injuries corroborates. Then her husband, of course, she said my husband was also a witness, but then he died. When they had given their 161 statements, her husband was alive, his statement might also be there. And then her husband also died. They were scared at that point of time. Thereafter, they clarified. Can be a case. Evidences are very less, of course. The evidences are very less. But
Yeah.
contradiction will go at the time of hearing, whatever Lordship. Just like-
My lord, my son,
Is it this Trimukh Maruti,
Huh.
this case? Now, where the explanation is supposed to be made.
Hmm.
Even if a false explanation is made,
Hmm.
that that cannot be a circumstantial evidence in itself.
Yes, as a last resort.
No, it cannot. It cannot supply the link to the chain. That's what has been,
And that's what I have also placed one decision, I think.
it only lends credence.
Lens credence, yes.
Only lends credence to the circumstantial evidence, which in itself,
Hmm,
excluding that additional
hmm,
link, should point towards the guilt of the.
yes. Prosecution has to stand
Yes, on its
And
own, without that
yes.
false alibi.
without that false incorrect statement or
Yeah.
whatever. That I had placed on the other, not only Trimukh Maruti, there was another old case that I. had
Trimukh
placed.
Maruti does not
Also.
specify,
Uh-huh.
does not clearly show that.
Hmm. But that only lends credence. That cannot become a link rather.
Yes.
That is there. Prosecution has to be. But here, in view of the statement of PW2, of course, two different statements, which he had admitted,
But gone to the house of this
had gone to the house of this
and was beaten up,
was beaten up.
but
Thereafter, she was taken to the hospital and
no, thereafter she stated she was brought again to the bed and kept in the house.
that
so,
he left her in her house.
so how does that help her? She's going,
No,
she's on her last breath and
My
how
lord,
does that help?
here, my lord,
It's like,
Well, here-
it's like saying someone has been raped. After raping, he's been brought back to our house. So that does not amount to rape.
No, my lord, here,
Yeah.
that is a different issue, my lord. Here I'm saying only with regard to the eyewitness aspect.
Only one thing is that wherever the others were identified also.
Already.
Lordship will visualize this, those people are from a lower strata and then there's a witch hunting case. People will not like to come and depose.
No, my question is,
Hmm.
if the appellant has been convicted
acha.
on the basis of the
Hmm.
evidence given by
Huh.
PW2,
Hmm.
why not the others?
Yes, because I think there's a reasoning saying that names of other accused were not there. And it was taken to the house of the appellant. So the house of the appellant is the only evidence. So benefit of doubt was given to other accused and he is the one who was convicted. House of the appellant, this is the basic thing. And he did not explain. He did not explain that, I think, house of the appellant to question to person.
No,
Whether that question was put that.
it's a false statement he stated.
false
How can we expect from a this section of?
To your house. So what happened in your house? So he did not explain. He simply said false.
We cannot, since we cannot expect much from PW,
Ah,
we
yes,
cannot
yes.
even expect many from appellant also. Both belong to the same strata.
But she was badly injured, that and she died
Ah.
because of that.
My lord,
Yes.
that is there.
Now this contradiction, whether it will go to the root and will make the PW2 unbelievable, then we will have to brush aside PW2.
Yes, where was who took her to hospital?
The
It
villagers.
was, as per their version, the son and the
Uh-huh.
daughter-in-law.
Took her to hospital.
Yes. To a local hospital, thereafter to North Lakhimpur Civil Hospital.
That is. The-
So PW2 is basically giving two versions.
Hmm.
In the examination in chief, she
Hmm.
says that she saw.
Hmm.
In her first, she says that she heard
Yes. From her mother.
from her mother.
In her 161, it seems there was a dying declaration. It can be a dying declaration when the
Oral line.
oral dying declaration. And in her trial statement, she seems to be an eyewitness. I can check her husband's statement if her husband's statement is recorded
Is it there?
by the
Is the
police.
LCR there?
LCR is here.
Yes.
Huh? Husband or naam kya hai?
No, no, record
She
নাম
will write,
husband or
wife
নাম, wife of লিখা নাই, father name, father's name লিখিছে।
Father name to any
Father name তো না, হানুফ সুরিন, এনেকে।
Hanup Suri.
বাপেক নহয় না, বাপেক।
No, father
Late,
format over.
late,
Husband also there.
হ'ব পাৰে, হ'ব পাৰে। হানুফ সুৰিন। কি সুৰিন?
Hanup Suri. Hanup Suri.
Hmm.
Statement of injured witness. Injured examiner, of doctor. Then Hanu Surya.
এইটো এই-
Okay, right.
Not
Just
yet.
when it was. Heard Miss
SG বললাম একটা।
A.G. Barua, learned counsel for the applicant defendant. Also heard Miss L. Jahan, additional fee. This is an application under section 389 CRPC for suspension of the sentence. Passed in connection with the judgment dated The judgment dated,
Page one of the appeal memo.
judgment dated 18/1/2023, passed by the Court of the Additional Sessions Judge, bracket FTC, comma, Lakhimpur, comma, North Lakhimpur. In Sessions Case number 122, bracket N full stop L, bracket close, slash 2015, comma, by which the appellant was convicted under section 302 IPC and sentenced to undergo rigorous imprisonment for life with a fine of rupees 5,000, in default imprisonment for 2 months. Next paragraph. The petitioner's counsel submit that the conviction of the appellant has been made only on the basis of the evidence of prosecution witness -2, bracket PW, who is the daughter-in-law of the deceased. She submits that the evidence of PW2 shows that PW2 had seen the deceased being taken away at night by the accused person to the appellant's house. And thereafter, they had brought back the deceased to their house. The PW2 and her husband thereafter took her mother-in-law to the Harmuti T Estate Hospital for treatment. As the doctor in Harmuti T Estate Hospital stated that treatment could not be done, the PW2's mother-in-law was taken to Lakhimpur Civil Hospital, where she expired during treatment. The appellant's counsel submits that in cross-examination, PW2 states that she had heard about the assault made on her mother-in-law from her mother-in-law, who was injured all over her body and blood was oozing out from her mouth. PW2 stated that she had been assaulted in the house of the appellant. Next paragraph. The appellant's counsel submits that the contradiction made by PW2 in respect of in the manner in which during the examination in chief and cross-examination shows that PW2 is not a reliable witness. And as such, no conviction could have been made on the basis of such evidence. Next paragraph. PW2 also states, and the petitioner's counsel also submit that PW2 in her examination in chief had stated that her mother-in-law had been nailed, bracket Gojalere Mora, right? However, the same was not supported by the evidence of the doctor who had done the post-mortem examination of the dead body of the deceased. Next. The appellants, the petition counsel also submit that that as all the other co-accused have been acquitted, there was no justification for the conviction of the appellant. As PW2 had also implicated all the other co-accused. Next. Yes, anything, Ms. Jahan?
No, husband, a statement I've checked, he also said that after coming back home, we had seen mother lying injured and about the oral dying declaration.
And the body?
And about the oral body, no, mother was lying on the bed with injuries because it was dead at night. So he did not take her to the hospital. In the morning they took. And about the oral dying declaration.
My lord has.
About the diabetes.
My lord
Mother said, even the wife said, mother said.
my lord has put one query that, with regard to whether that accused person was the one who has taken him to the Bulsa's house, whether that accused is Bulsa or not. In 161, as per the version, it has stated that, as per 161, that someone has
160, who's 161?
of the PW2.
Okay.
That,
What does it say?
it says that as per the Assamese version, someone has taken me from the house and has taken to Bulsa's house.
The mother said.
As per 161, my lord has put query whether that someone, amongst that someone with a Bulsa was there or not, so with regard to that query.
That is one aspect that slightly bothering us.
Because it said, my lord, may I, oh.
Her 161 cannot be taken into consideration to reach that conclusion that it was not he who had taken. In her statement before trial court, she said accused persons. 161 cannot be taken into account, but technically, I mean.
Just my lord has put one query. With that regard, I have just read the 161 and I have stated.
Okay, all right. Ms. S. Jahan, Learned Additional PP on the other hand, submit that the evidence of PW2 clearly
My
show-
lord, my lord, 161 of the husband is different. The 16 who expired, as per the Assamese version, moi ghorot ahi mak, together they came, wife and PW2 and the husband. Moi ghorot ahi mak bisonat pori thoka dekha pa. I came home and I saw my mother lying in the bed. Mukhedi kekai asil. She was stammering from mouth. Kotha botora kobo nuara gute gat chokhaman. She was not able to say anything. Whole body was.
But then after that,
No.
she said.
No. Yeah. This is the husband's. Both of them came together.
একাই আছিল কথা বতৰা কব নোৱাৰে গোটেই গাত আছিল নিশা বেছি হোৱাৰ কাৰণে চিকিৎসাৰ বাবে আচ্ছা he did not say আজি ইমান তাৰিখে ৰাতিপুৱা আচ্ছা he initially he said গাঁৱৰে নামৰ ঘৰত ঘূৰিবলৈ গৈছিলো ঘৰলৈ ঘূৰি আহোঁতে ৰাস্তাতে সুভাষে what is his name ভূষা কলে যে মোৰ মা গাঁৱৰে সুভাষ আৰু কেইজনমান মিলি গাঁৱৰ পৰা ধৰি নি মাৰপিট কৰে মই ঘৰত আহি মাক বিচনাত পৰি থকা দেখা পাওঁ আচ্ছা he did not talk about the oral dying declaration that I stand corrected he did not say he
And
simply
they came together.
Yes, they came together.
and wife statement I'll just read it out again she said তেজ ওলাই আছে ঘৰৰ শাশু বুঢ়ীয়ে কলে খা খবৰ কৰাত when asking about
When I inquired.
and when I inquired then my mother-in-law said শাশু বুঢ়ীয়ে কলে শাশু মাক কোনোবাই ঘৰৰ পৰা ধৰি নি পুৰুষাৰ ঘৰত মাৰপিট কৰি আকৌ ঘৰত ঘূৰি. So mother-in-law said that someone had taken her to appellant's house where she was assaulted and she was brought back and kept in her own place.
Both son and daughter-in-law came together. They have stated in 161 also, even in the proposal.
Both son and son, what?
So both son and daughter-in-law, that is PW2 and the son, came together. My lord, yes, but the son said that she could not. She could not, she was murmuring something, but she could not say anything because her blood was oozing out. She could not say anything. So thereafter, they took her to the hospital.
It can be a fact that her daughter-in-law spoke to her. They reached together. It's not that both of them asked her mother-in-law. Mother-in-law, daughter-in-law might have asked mother-in-law before son reached. Can be a situation, but then fact remains, son is not before the court. At best, his statement can be considered under section 33 of the evidence because he is dead.
Who
But
said-
then again, 33 it cannot be.
Son is dead.
The son is there.
No, even 33 it cannot be.
Was he alive during the time the evidence was taken?
No, my lord,
No.
that is what I was saying. Mother-in-law died. Thereafter, some months, son died, she remarried.
Son died. He could not depose before the court. He
Son
died
also
before-
died in that way only on information from the accused. At night, he was all healthy, coming from work. In morning, all villagers get he died. He was already lying.
No, we will brush aside
But
some
that is
statement.
different, that is different.
We'll
but
brush aside to then daughter-in-law.
Maybe and must be
Her
cannot be, my lord.
contradiction. In my submission, her contradiction, she herself admitted. And her admission shows that she was perhaps scared at the first point of time. Thereafter, she stated the facts before the trial court. Because she did not say, I have not stated before police so and so.
But then can we say that the contradiction made allows us to, believe one part of her testimony and disbelieve the rest?
Difficult. Moment contradiction comes and it goes to the root, it becomes unbelievable.
Okay, right. Whatever you said. Clearly shows that the deceased had been taken to the house of the appellant where she had been assaulted. And as such, the complicity of the appellant in the death of the deceased has been proved. That's all. Next. On considering the fact that there is discrepancy in the evidence given by PW2 in her examination in chief and in her cross-examination. Besides there being no other evidence against the appellant. But then this will go to again, okay, the entire case.
It will go in the, yes, sir.
Okay,
Like
no,
allowing-
don't try to cut that. You cut that. That's right. On considering the fact that on considering the fact that on considering the submissions made by the counsel for the parties, and keeping in view the evidence. Keeping in view the discrepancy made in the evidence of PW2, we are of the view that the sentence, we are of the view that the sentence should be suspended. Accordingly, the sentence passed in the sentence passed in connection with in the judgment dated so and so, judgment dated
Is one of the
18/1/2023 passed by the Court of the Additional Sessions Judge FTC Lakhimpur, North Lakhimpur, in Sessions Case number 122 bracket NL/2015 is suspended. The appellant and the applicant is accordingly granted bail on a bail bond of rupees
20,000 or something, 40,000.
50,000 with one surety of like amount to the satisfaction of the learned trial court.
Well, I don't know they have land or not, but 50,000, I don't know. my lord.
Okay, 40,000. With one surety like amount to the, you're not paying cash,
Ah,
it's just a
That-
bond.
my lord,
It's only a bond.
The land, what happens is that with regard to bail bond, my lord,
The,
if we do not
the
give
surety will take
arrears-
some money.
no, 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 my lord, if we don't give proper, the exact land documents, then we have to deposit the money. And so this is the problem, because my lord, no one wants to be a bailor in certain cases, and these people don't, generally, they used to reside in T areas, so my lord, that is the problem.
Okay, make it 30,000. With one surety to the like amount to the satisfaction of the trial court. The, any observations made in this order shall not be considered to be the final observations. Any observation or finding made, no finding has been made, I think. Any observations made in this order shall not be considered to be a final observation at the time of hearing the final, at the time of hearing the is accordingly disposed. Then in the main case,
The
you're right,
appeal,
as
paper-
the,
paper-
as LCR has arrived, a registry to prepare the paper book and list the matter
Of course,
in due course.
obliged, my lord, highly obliged.
No, don't say that. And then they prepare the paper book for some, this is the matter after 6 weeks.
Yeah.
At least some time period, others will come after 2 years, 3 years.
Uh-huh.
Obliged, my lord.
May three, Lord. So in this case, this appeal has already been admitted, Lordship. But
Huh?
the appeal has already
They have
been,
not taken steps.
Lordship, we are required to take steps, Lordship, after respondent number 2, Lord.
Then
At least 10 days time may be granted.
This will again through me. I will.
why did it come so fast? Why did we list it today? By mistake?
Oh, there's an office note. It is for orders.
Okay. Okay, right. As per office, Mr.
R to come.
R. Fokan, London Legal Aid Council appears for the appellant. While Ms. L. Jahan, additional PP, appears for the state. Full stop. As per the last order dated 21/6/2023, registry was to send notice to the respondent number 2 by a registered post detail. Full stop. However, we direct the registry to give copy of the notice to Ms. S. Jahan, additional PP, who shall thereafter ensure that who shall thereafter give the same to the OC of the concerned police station, who shall serve the same to the respondent number 2 and give a report thereafter. This is the matter after 4 weeks.
Yeah.
Obliged.
Yeah, please. Lordship, in the respondent number 2, the notice was served, is unserved, Lordship. As per office note dated 27/7/2023.
Here is the main appeal. You have filed a written objection.
Lordship, the LCR is also there.
So you are taking steps.
Yes, Lordship, but it has been unserved, Lordship. I may be allowed to take steps through the concerned police station, Lordship.
No. Okay, you will take OC or PP will take. You will take.
Lordship, as the Lordship may direct. Is there?
Lordship, as per the new honorable court's order, your lordship, we need to take steps through OC.
PP yes.
Kolaiga also.
And what about the IA?
Lordship, it may be taken after some time, seen his own legs.
We'll wait for your senior, no problem. Oh, what?
If you wishes, let the matter be taken up on some other day.
Some other day, okay, right. In the main appeal, you write. Mr.
A Bhattacharjee.
A. Bhattacharjee appears for the appellant. And submits that as per the office note dated 27/7/23. Unserved notice has been received back. In view of the above, the additional PP, Miss B. Buyan, shall take steps for service of notice to the respondent number 2 through the OC.
Notice this, lordship,
Who will take the steps for that?
no, I'll do the
Uh,
needful.
What have I said? In view of the above, the appellant shall give a copy of the notice to be served to the learned PP, additional PP, Ms. B. Buyan, who shall thereafter communicate the same to the OC of the concerned police station,
Kolaigaon, Lordship.
the
Kolaigaon Police Station.
Kolaigaon Police Station. For service to the respondent number 2. Full stop. The additional PP shall thereafter make a report of the same. This is the matter after 4 weeks. Then in the IA, you write, Mr. A. Bhattacharjee, learned counsel for the applicant, says that the matter may be adjourned. Full stop. Accordingly,
Lordship, it may be taken today after some time.
may be taken on some other date. Don't say that, may be taken on some other date. Full stop. Accordingly, leave this matter after 4 weeks.
Please, your lordship. There's a 389 petition lordship for suspension of sentence and all. For the
Yes.
first time it has come up. I think the state will be filing a written op.
Lordship, actually, we have no. copy
Right,
of the
heard,
item and
mister?
all not there with me.
VH Chaudhary. You have Mr. A.M. Bora.
And Mr.
VH Chaudhary.
V. A. Chowdhury, on behalf of Mr. A. M. Bora, learned counsel for the applicant, who feels that yes, application under 389 CRPC should be allowed. Ms. B. Buyan, addition BP is granted 4 weeks time to file written objection. This is the matter.
Let them be directed to provide copies, my lord. I don't have any.
Actually, you're not giving.
No, we have given.
They have given unless they
They
give,
have
they
misplaced,
cannot,
I suppose,
our office lordship, let them give an extra copy.
because their name has been shown in the call list. We have served the copy. Lord.
He
Let
says
them
that-
give
Required,
extra
we'll
copy.
serve it again, Lord. No
Ah,
problem. If
okay.
required, we'll serve it again.
This additional BP is granted 4 weeks time to file written objection. The applicant's counsel shall serve an extra copy to the additional PP within 2 days.
2 days. Lord.
This is the matter of the point.
Highly obliged. May please your lordship. My lord, otherwise these appeals were fixed for hearing in due course. But I have filed an IA that is before your lordships today. Your lordship will kindly take up the IA one
No,
nine
no,
nine eight.
the appeals are to be heard
Appeals were to be heard
of this court has been drawn to the fact that the present appellant has been convicted under section 302 IPC, while the co-accused Dilip Buyan has been convicted under section 201/34 IPC. The apprehension of the parties is that this court might have already disposed, might have apprehension of the parties is that this court might have is that Dilip Buyan, the co-accused Dilip Buyan, may have filed an appeal and which may have been disposed of. Thereby enabling the appellate court to have come to a finding as to whether PW4 was a reliable witness or not. First of all, in view of the above, registry is directed to make a report as to whether Dilip Buyan has filed an appeal against the impugned judgment dated 26/4/2021 passed by the Court of the Additional Sessions Judge, Sivasagar in Sessions Case number 269 bracket S-N bracket close of 2017. Page 43, page 43. Please. If it has been filed, the status of the appeal should be indicated.
Apprehension of parties instead of that apprehension. of the
Apprehension,
affair.
okay, instead of apprehension of the parties, say apprehension of the learned amicus curiae.
Because there is a Supreme Court judgment that any case arising out of same FIR that ought to have been listed before same bench together.
But
That
5
extended
years and life
observation is there.
conviction,
Therefore, I have
how
pointed
can
out.
they list it together? 5 years.
5 years and this cannot be listed together, but it could be. Why not?
In generally, those things are, those cases are
10
taken
years
up
or more,
together.
your lordship,
That
before
is, but the only problem is what he's saying is correct. Supposing that person had filed an appeal and supposing the single bench of this court had come to a finding that the evidence of PW4 was reliable. While in this case, he's going to say that it is not reliable.
Not really.
That is your case.
Yes.
Let us see in the method proxy.
Item 16 is there, no? I'll list the matter after
After 1 week.
no, some time I think. This is the matter after 2 weeks.
Lovely.
Sixteen is a POXO matter, so lordship, in view of the Supreme Court.
This is, of course, I can tell you, let it, redo it and again, given that can be done. Feasibility, his own guidelines say there has to be feasibility, it will be consulted.
In the bottle envelope. No. It is the envelopes are there below.
Last, there is an order to distance. What is the distance? This is what last order was passed by this court.
Yes.
No, as per last law, I have taken the instruction, my lord. As per the instruction, my lord, the space, my lord, from the intersection, the whole space is 5 kilometer, my lord. Now, at this moment, my lord, until unless one LY could be issued to a particular person, candidate, my lord, candidate, candidate, my lord, we cannot say, my lord, it has.
No, Mr. Counsel, did you understand the question?
Yes, my lord.
The question was, what is the distance between the petitioner's petrol pump and your proposed petrol pump?
That's why, my lord, at this moment, because my lord, several candidate has participated in a tender process, my lord.
Okay, so different land.
Different land, my lord. So in what location, my lord, he has to apply, my lord.
No, but then,
Then the.
okay, let me put it in another way.
Yes, ma'am. Because it is a 5 kilometer stretch, my lord. If somebody, my lord, offer a land, my lord, which is 4 kilometer from the intersection, my lord.
You see, his case is that his land is before the intersection. His land is before the intersection.
No, my lord, it is within the intersection, my lord. If it is beyond the intersection, my
Yes,
lord,
but then the land of others are beyond the intersection.
My lord, I'm sorry to say, they have selected, some private respondent appeared. 173 is their drawing. They say that this is the proposed.
Page
What-
173.
Page 173. That's it, your lordship is saying,
but
what is the distance between the, that's what your
but
lordship
that
is
is
asking.
before, my lord, advertisement, my lord. The feasibility report was done, my lord. was
Okay,
carried out, my lord.
with the present advertisement also. How much is it? You have already selected.
So once.
No, have you selected or not?
So one person is selected, my lord, but
Aha.
this selection does not give me right, my lord, because there
Correct, correct.
is a land evaluation committee, my lord, then FBC, my lord. And
Look,
now we cannot say that this person has to be, my lord.
You are neither here nor
Commission,
there.
madam.
You are neither here nor there.
Yes, my
It's a
lord.
very simple question. Okay, the person who has been selected, what is the distance of his petrol pump with the petitioner's
Yes.
petrol pump?
But because of the stay order, my lord,
No, Mr. Council. Because of a stay order is a different thing. If you're not going to answer, we'll call your big bosses out there. We'll make them answer if you cannot answer. Please don't try to act in a very funny manner. It's a simple question. What is the distance between the land of the person who has been selected and the petitioner's petrol pump? What is the distance? That's all we want to know. What is so difficult?
I'm taking upon data to know, my lord.
And you also find out the difference between the distance between the land that person who is selected
Yes, my lord.
and the petrol pumps,
And a petition of petrol, my lord.
petitioner's petrol pump plus Saini service station and AIE Valley service station. Only that. That will clarify everything. Otherwise, he's got no right. But then because of the thing is that when you're making a feasibility report, you have taken into consideration petrol pumps that appear to be further away than the petitioner's petrol pump. That does not seem to be correct. Okay, right. Mr. S. Thakur, learned counsel for the respondent number 3. Praise for 2 days' time to obtain instructions as to the distance between the petitioner's petrol pump and the land in which the successful tenderer, in which the successful tenderer is proposing to set up a petrol pump. Full stop. Prayers allowed. Full stop. Further, the respondent number 3's counsel shall obtain instructions as to the distance between the successful tenderer's land and Saini service station, SAINI, and AIE Valley service station. AIE Valley service. So there is a stay order, is it?
Yes, it's continuing from.
But prior to that, they're already selected.
It's already there,
And AIE Valley service station.
prior to that.
This is the matter. After tomorrow.
But after 1 minute, it will take
Huh?
some time. It will take some, after 1 minute, it will
One
take some
week.
time. Because the orders have
week,
go
eight
to
days.
the place.
Okay, list the matter. 9.
9 minutes, I will out of the station.
Okay, you give a date whenever you want.
Huh? Eight. On 8 minutes.
8.
Woman, it's a case of the. There are a lot of, now the not that, don't matter as it.
It's a hard.
No, 9.
Sixteen.
16.
60. Simply of it.
What is this matter? I did not.
This is a review petition, my lord. Of course, Lordship did not deal with the matter. Oh, sorry, Lordship, sorry, I'm sorry. No, in between it was listed before some other court. My lord, review has been filed. Now, my lord, there are before even,
Vinat is appearing, Lordship is coming.
Huh?
Mr. Dina, is on Lex Lordship.
Okay. Oh, there is one thing, you were supposed to file some affidavit in reply. As per the last order.
Lordship instructions received Lordship.
Instruction received, have you filed?
Not Lordship. Maybe it's prepared Lordship. Lordship just, yes.
Okay, you go and obtain instruction. Yes, he wants review of the order. I have
Yes.
not read, what is the, I mean,
Actually, what had happened, my lord, the petitioner, my lord, his petition was allowed. Because, my lord, what had happened, while he was working in the establishment of the deputy commissioner, Dhubri, my lord, he was given a posting to, within the same establishment. And there was a shortfall of 2 months. Then, my lord, government did not condone that. Then we filed the writ petition, the lordship allowed the writ petition saying, by review TPC, my case should be considered. Now they are bringing in a plea that this benefit can be given only to the ministerial cadre of the Directorate of Food and Civil Supplies, not to, my lord, the establishment of deputy commissioner. Now, my lord, this aspect of the matter was earlier gone into by a single judge of this honorable court. The matter was referred. But the government has taken a call that no, for the present will continue with this until the rules are amended or something like.
so that means a DC establishment official can
Yes,
be appointed.
yes,
Now, where is that?
yes.
Lordship,
If your lordship would kindly have the affidavit which you have filed, madam. Please come to my lord, page 43.
Page 43, yes.
Yes, that is the order passed by Justice B.K. Sharma, my lord. If your
Yeah.
lordship would kindly come to page 44,
Yes,
paragraph 3.
yes.
According to the petitioner, as per the provisions of Assam Supply Service Rule 70, as amended in 89, it is only members of the ministerial cadre under the directorate are entitled to get promotion and not to be member of the ministerial cadre of deputy commissioner subdivision establishment. Then my lord will kindly come to the next page, para 10. It will have to be borne in mind that for Director of Food and Civil Supply, the rules applicable is Assam Supply Service Rule 1970. It also have to be borne in mind that establishment of Directorate of Food and Civil Supply is a separate entity than the establishment of the Deputy Commissioner and Subdivisional Officer. While it is true that there are branches of food and civil supplies in the establishment of Deputy Commissioner, Subdivisional Officer, but that by itself may not mean that the said establishment are within the establishment of Director of Food and Civil Supplies. As contended by the petitioner, the amended provision is applicable only to those members of the ministerial cadre referred to in the amended provision who have been made to work in food and civil supply branch of the establishment of Deputy Commissioner and not to ministerial cadre of establishment of the Deputy Commissioner and divisional officer, subdivisional officer. Then my lord will kindly come to next page, para 14. Para 14, madam. As per the provisions of the Assam Directorate Establishment Ministerial Service Rule 73, which is applicable to the ministerial cadre of the establishment of Deputy Commissioner and Subdivisional Officer, there is promotional avenue from the post of LDUJ and thereafter to superintendent, etc. Unlike the promotional avenue in the Directorate of Food and Civil Supply, it is in this context S.B. Prasad Learned Counsel for the petitioner has submitted that unlike the said promotional avenue in the Director of Food and Civil Supply, provision has been made for promotion to the post of sub-inspector from amongst the ministerial cadre, 25%. MS so Learned Counsel representing private respondent has referred to clarification dated 12/7/89. It was so 12/7/89, which is under challenge in the instant writ petition. By the said purported clarification, it was only conveyed to the Director of Food and Civil Supply that LD, that is, who have rendered 5 years of continuous service in the separate branch are also entitled to get promotional benefit. However, the question raised in the aforesaid letter of director have not been answered. From the above, the question which falls for consideration is as to whether by aforesaid purported clarification falling back on the amended provision of 73 rule, provision would have been made for promotion of the members of the ministerial cadre of the establishment of the deputy commissioner, subdivision officer, which government in the food and civil supply department will have to answer by referring to provisions of the rules and intention behind the amendment that was brought in 79. For all the aforesaid reason, both writ petitions are disposed of, directing government in the food and supply, civil supply department to look into the grievance of the petitioner in reference to the relevant rules and amendments brought therein and also consistently with the observations made above. It will be appropriate for the government to pass a speaking order. Let the required exercise be carried out as expeditiously as possible, preferably within 31/8/21, upon hearing all necessary parties. So, in effect, my lord, this honorable court left the matter to the government to take a call. Now, government has taken a call, my lord. That portion is quoted in an order of this court, my lord. Please come to my lord, page 49.
Yes,
Please come to that italics portion, my lord.
yes.
Now, therefore, having considered and the facts as stated above, and taking into account all factors relevant to the case, it is ordered that promotion to the cadre of sub-inspector, food and civil supply from LD of amalgamated establishment of deputy commissioner in the establishment so far made is not irregular, as relevant rule is not specific in respect of the lower division assistant of slash subdivisions. However, considering the fact that there are also separate avenues for promotion of the ministerial staff of the amalgamated staff of the deputy commissioner, eligible ministerial staff of directorate of food and civil supply and of food and civil supply consumer affairs branch of the amalgamated establishment of deputy commissioner, drawing salaries under food and civil supply and consumer affairs head of accounts for a period of 5 years or more, relevant rules need to be amended and made more specific accordingly. So matter is at that stage. So therefore, the plea now which is sought to be urged, now this is the same government who has clarified it, and another government is filing a review.
Lordship, just in 2 days, we will file our affidavit, Lordship.
Where is your senior?
And Lordship, he is on legs left, Lordship. Code number? Sorry, code number 7, Lordship.
Huh?
Code number 7, Lordship, is on legs.
And yeah, madam, she's very fast.
Okay, right.
And my lord, we are also raising the plea of delay, madam.
Okay. Right. Miss
Take a look at.
A Talukdar, haven't seen you for a long time, that's why
Lordship,
forgotten your name.
Lordship.
Miss A Talukdar submits that her senior, that Mr. Dinar,
Lordship.
the additional senior government advocate.
Senior,
Senior government
That is,
advocate,
the
Lordship.
senior government advocate is on his legs in court number 7. She also submits that affidavit in reply will be filed within 2 days. First up. On the other hand, Mr. K. N. Chaudhary, London Senior Counsel, submits that the issue raised by the review petitioner has already been answered by the speaking order.
It took 1 hour. My lord, date, my lord,
Speaking order issued by the Commissioner Secretary to Government of Assam,
yes.
FC
Food and Civil
SCA
Supplies and Consumer Affairs Department.
which is reflected in para 3 of the judgment and order dated 28/4/2020, passed in WPC 779/2015, which in turn had been passed, which had been passed in terms of para, which had been passed in
Yes.
terms of para
16, my lord.
para 14, 15, and 16
Yes,
of the judgment passed in, is it IA or WPC? What is it?
WPC, my lord,
WPC.
8769.
8769/2005. He also submits that the review petition suffers from delay. On considering the submission of Ms. A. Talukdar, 2 days time is granted to file. Release the matter after.
Next Monday or this Friday, my.
I won't be here this Friday.
Oh.
I've got a meeting in Aizawl.
Okay.
I've got to attend. So I probably will be going on
Next
Thursday or
week, my
something.
lord, whenever lordship is there.
Release the matter after a week. It's a
Ah,
review, it'll come.
It's okay, okay.
Release the matter after a week.
Deep level.
Keep your obliged lordship.
This back problem is improved.
Not 100%, 95.
I think physiotherapy is the only way out.
I don't know. I think it'll continue to remain now, I think. I don't, I have no idea.
That's why I think physiotherapy is the best. No medicine can help.
The best is that we shouldn't sit too long.
Exactly.
That is it.
Right.
What to do? We have to sit all the time. Finish. We could have finished this matter actually. If we have finished our test. Actually, we could have gone through the,
Lordship, just now I got the report. Keep your obliged lordship.